Good morning, this is your Kelso Report for Tuesday, February 21st, and I'm your host, Clark Kelso. Today we have a case involving land use, preclusion, immigration, and criminal law. First, let's begin with the Ninth Circuit and an interesting land use decision. The city of Yucaipa, California, adopted an ordinance creating a senior mobile home park overlay district. This ordinance prohibits any of the 22 mobile home parks in the city that currently operates as a senior housing from converting to all-age housing. Several of the mobile home parks challenged the ordinance under the Federal Fair Housing Amendments Act. The act generally prohibits discrimination in the rental or sale of a dwelling on the basis of race, color, religion, sex, national origin, or familial status. The Act provides two exemptions to the prescription against familial status discrimination. First, restrictions on maximum occupancy can still be enforced, and regulations regarding housing for older persons remain protected. The senior exemption covered housing, quote, intended and operated for occupancy by at least one person 55 years of age or older per unit, close quote. The mobile home park owners claimed that the ordinance violated the act because it forced the park to discriminate against families with children in favor of older residents without families. It claimed the senior exemption did not apply because the language of the statute referred to housing, quote, intended, close quote, to be used for senior housing. And according to their argument, the word intended referred to what the park owner intended, not what the city intended. Well, after reviewing a largely inconclusive legislative history, the Ninth Circuit held in Putnam Family Partnership versus City of Yucaipa that either the park owner's or the city's intent was sufficient to trigger the federal exemption under the Act. Therefore, the city ordinance was a lawful exercise of the city's land use powers. Next, we have a case involving the doctrine of preclusion in the context of environmental litigation. One of the primary threats to sea turtles is the use of trawl nets by commercial shrimp harvesting vessels, since the sea turtles frequently get trapped in the nets and drown. Federal law requires that domestic shrimp trawlers use a turtle excluder device, which is a grate that keeps sea turtles and other large animals out of the nets while letting shrimp pass through. Isn't it amazing what you learn from reading cases? But this is more than a domestic program, or a domestic problem. So Congress authorized the State Department to bar importation of commercially harvested shrimp from a country unless the department makes an annual certification that that country has a program to reduce the incidental turtle take. The State Department promulgated regulations that were challenged by the plaintiffs in several lawsuits on the grounds that the regs conflicted with the authorizing statute. The plaintiffs knew at the time that they also had claims based on a possible violation of the National Environmental Protection Act, NEPA, and the Endangered Species Act. But they elected to work with the State Department on those issues. Well, when the State Department issued its certifications in 2009, the plaintiff filed its action challenging the certifications under NEPA and the Endangered Species Act. Last week in Turtle Island Restoration versus U.S. Department of State, the Ninth Circuit held that the plaintiff was precluded from bringing its new legal theory because the State Department's implementation of the program was res judicata insofar as the plaintiff was concerned. As the court noted, quote, not only could the plaintiff have brought its NEPA and ESA claims during its prior litigation, but because the claims arise from the same transactional nucleus of facts, the plaintiff had to bring its claims then, close quote. So the plaintiff's case is dismissed. If there's going to be a challenge based on NEPA or the Endangered Species Act, some other plaintiff will have to bring it. Our last Ninth Circuit case involves an immigration issue. An alien, in the case of Latter Singh versus Holder, had entered the United States illegally in January 1993 and received a grant of asylum in September of that year. However, he never obtained legal permanent residency. Subsequently, he was convicted under Penal Code Section 422 for making threats with intent to terrorize. The federal government then commenced removal proceedings against him based on its assessment that he was subject to removal as an alien convicted of a crime involving moral turpitude. The Ninth Circuit examined whether the full range of conduct encompassed by the criminal statute constituted a crime of moral turpitude, and concluded that a violation of Section 422 was indeed a crime of moral turpitude as a categorical matter. And the court therefore rejected the alien's appeal. Last today we have a criminal law case from the California Court of Appeal involving the procedures for a plea of insanity. In People v. Level, the defendant's counsel rather carelessly waived his client's right to have a second mental health professional examine the defendant with respect to his insanity defense. It may not have mattered on the merits, but it certainly was a casual enough waiver. Penal Code Section 1027 provides in part that, quote, when a defendant pleads not guilty by reason of insanity, the court must select and appoint 2 and may select and appoint 3 psychiatrists or licensed psychologists to examine the defendant and investigate his mental status, close quote. Well, the pretrial proceedings in this case were extraordinarily protracted. The defendant pled not guilty in 2005. 2 years later, he added a plea of not guilty by reason of insanity. The court immediately appointed one Dr. Clark to examine the defendant. And defense counsel did not request at the time the appointment of a second mental health professional. Dr. Clark issued a report 1 month later in which he found the defendant sane during the commission of the crimes. Well, there were more delays. The trial finally was ready to begin on March 9, 2010, more than 2 years later. At that time, the defendant re-entered the insanity plea and again requested the appointment of one mental health professional. The court obliged and appointed a Dr. Alan Killian, but then the very next day noted that there had been an insanity plea back in 2007, and Dr. Clark had been appointed and submitted a report. Defense counsel expressed surprise, apparently having forgotten what happened back in 2007. And then, at the court's slight prodding, the defendant withdrew the referral to Dr. Killian and went forward with the trial. On these facts, the appellate court held that the defendant had forfeited appellate review of the statutory requirement that 2 mental health professionals be appointed. And that's it for today's Kelso Report. Have a great day in the law.